Hello and welcome to Immigration and Jobs Talk Show. I'm your host Sam, and thank you so much to each one of you for joining us today. We have got a great episode today, and we are really excited to have you all with us. But before jumping into our today's topic and welcoming our guests, it's always better to read an important disclaimer. Well, that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. Well, I know you all might be expecting Nipasa, but she is actually not unwell today. So please pray that she feels well soon and can join us again. But not to worry, I'm here to be your host for today. Once again, guys, welcome back to Immigration and Jobs Talk Show. And let me tell you that we are live on YouTube, LinkedIn, Facebook, and Twitter as well. So, without any delays, let's invite our today's guest, none other than Attorney Chand Parvathaneni. He's the managing attorney at the law firm of Parvathaneni and Brown, based in Dallas, Texas. He also has an experience in immigration law. So, Chand, how are you doing today, and how you are doing today?
Hello, Sam. Pretty good, and I think we just it's pretty bad summer right now in Dallas area, and it's very hot. I mean, it's extremely hot, and we're just hoping in the next 2-3 weeks the weather gets better, and we'll enter into the fall. So hopefully our summer should start slowing down, and hopefully it's a lot better in Dallas area.
Well, we hope so. In fact, in India also, the weather right now is quite humid, but that's okay. Our show must go on. And Chand, it's really great having you all the time with us today. A huge thank you for you to, take out some time to attend our show and to be our amazing guest. Thank you so much, Chand.
Thank you, Sam.
Okay. So, folks out there, without any delaying, let me tell you what our today's topic is. Today, we are going to talk about September Visa Bulletin Shocker. Is your green card application at risk? Well, to me, this topic seems to be very interesting and informative. What can you say to our viewers, Shant, about this? That what they should expect from our today's topic.
Sure. I mean, again, the visa bulletin, it's a monthly bulletin. So as you all know, it's just like a monthly thing that comes out every month. We got the September bulletin, and in general, historically, the September bulletin is like a very, very bad bulletin. The reason is the fiscal year for USCIS. The fiscal year starts October 1st, ends September 30th. And every year, USCIS, they have a certain number of green cards that they can issue. So there are strict limits on the number of green cards. And what typically happens is most of the green cards start getting issued in the month of October. And as it gets to September, what happens is we're at the end of the fiscal year. September is the last month as per the government, the immigration fiscal year. So most of the green cards are taken up because they started issuing the green cards from October. So it is quite normal that normally the September bulletin, you might not have a lot of visa numbers out there, which means you can't really issue the green cards because all the quota is exhausted. And this typically means that you don't really see a lot of movement in the September visa bulletins. And that's what pretty much happened. And what that means is the dates did not move ahead at all, which was kind of expected. But in some of the categories, we actually saw the dates go back even further. So I think people thought, I mean, people didn't expect a lot of forward movement, but they did not expect a lot of backward movement. And in some categories, the dates actually retrogressed back, and especially in the EB3, the other countries category, the rest of the world category, it almost went back 1 year. So that was kind of a bit of a surprise. And for India, in terms of the dates, EB1, EB2, EB3, the dates are stuck wherever they're stuck, no forward movement. And I think some people were hopeful that at least they'll see some forward movement, especially the ones that are very, very close to the last month's priority dates. And that did not happen. But again, overall, I think we will discuss about the September visa bulletin, what kind of rules are in place, and what you can expect in the next a couple of months, and see what's going on. Again, generally the October visa bulletin is going to be a good visa bulletin historically. So even though the September visa bulletin is a little bit disheartening visa bulletin in terms of the numbers, I do think that starting from October we will start seeing forward movement. So I think that's something, I think what we will discuss. We'll discuss about the quota, how many numbers are out there starting from October, and various issues concerning this the current state of the visa bulletins.
Right, right. So I think today's episode is not just only going to be interesting, but needs to be a lot of informative, because as you said, that September visa bulletin is going to be a kind of disheartening. So it's okay, that's okay, but at least we should know what the pointers are. We should be aware of the every pointers that is going to happen in September thing. Okay, Chance. So, as you explained what viewers should out there should expect from today's episode, let's directly jump into our today's first question. That is, could you elaborate on the reasons behind the significant one-year retrogression in the EB3 category for applicants from all chargeability areas, Mexico's and Philippines, and also for India?
Sure. So the EB3 category in general, I think normally what we do see is they typically divide it into India, they divide it into China. The reason being, India and China are very, very um, areas with very high demand. So they typically have a separate date for India. They have a separate date for China and Mexico and Philippines, because they're also one of the highly oversubscribed countries in employment-based immigration. And the reason for this oversubscription is because we do have 40,000 green cards that are available under EB3 category. And out of this 40,000 visa, these immigrant visa numbers that are out there, what happens is we only can have 7% be issued to any single country. So there is this 7% country quota limit. So because of this reason, what happens is countries like India, which are heavily oversubscribed, which is probably the highest oversubscribed country in terms of the EB3 category, we have the most backward date. So the current priority date for India is October 2012. And what that means for the viewers is, if somebody actually entered this green card process in 2012, they were born in India. So if somebody is born in India and the green card process got started in 2012, those people are eligible to get green cards now. If somebody's green card process started in 2013, 14, 15, they are not even eligible to get a green card right now. So that's how bad the current state is for India. So 2012 October is the priority date. And what happened in September bulletin is, when we compare it with the August bulletin and the September bulletin, for India, the EB3 category, there was no movement at all. So it did not go back, it did not go forwards. It stayed wherever it is. So at least in terms of the retrogression, the good news is it did not retrogress back. So whoever thought they were current last month, they are still current. So at least until October 2012, we know that those people might be eligible to get a green card. More than likely, they will see a green card in the next 1 2 months. uh, because people who are having a green card filed, the process started before October 2012. A lot of them are still waiting because their 485 is still in process. So at least there is no backward retrogression. So people from India, whoever was current in the August bulletin, are still good even in the September bulletin. And now the problem with the rest of the countries, the rest of the world, what happened is that was a shocker. So they moved the dates back almost 1 year. And it was pretty surprising that the dates moved back 1 year for the rest of the world. So now they used to be in 2021. So they moved back to December 2020. So rest of the world, basically pretty much anybody from any country, if they have their green card process started after December 2020, sorry, before December 2020, they are eligible to get a green card right now. And if anybody's EB3 green card process started after 2020, and we're talking about the rest of the world, not India, but rest of the world, they are not eligible to get a green card. The dates moved back 1 year. So in 1 month visa bulletin, they went back 1 year. And the reason for that is the high demand. So the EB3 category, they can see a significant retrogression when there is a surge in the number of applicants. And if a large number of applicants, these 485 applications are filed, or these I-140s are approved recently in a short period of time, what happens is all of them file for 485s. They quickly consume the visa numbers. There is a set limit of EB3 green cards that can be given. So when we have a lot of these cases get approved in a recent time, uh, we see a problem in terms of retrogression. So what happened is 2021, 22, the markets were very good, and a lot of companies actually hired. A lot of companies actually also started applying for their perms, and perms are taking a very long time. And what that means is whoever started the perm process in the last couple of years, I think they saw their I-140s approved, and a lot of people with recent I-140s, 2021, 22, they started actually applying for 485s because the dates were current a couple of bulletins back, and the rest of the world's cases. And recently, because so many applications got filed, and it clearly looks like they ran out of the quota. And because they ran out of that quota, the 40,000 numbers that can be given in an entire year, this high demand also caused this retrogression, and dates for rest of the world moved 1 year back. The other big factor is the per country limitations. And as we know, for the green card process, there is a 7% per country limit. And if one or more countries hit the cap, the 7% cap, what happens is they will start retrogressing those countries back. And clearly looks like there was a lot of demand from rest of the world. And because of this reason, even the rest of the world quota, it had to be retrogressed back. And now we are looking at 2020. So the 1 year back that we are seeing is because of the per country limitations also as one of the factors. And also the adjustment of status filings. So what happens is people get their I-140s, and whenever the dates are current, people will start applying for 485s. And a few visa bulletins back, rest of the world was current for 2021, obviously, and 2022. So all these folks started applying for 485s. And as people whose 140s are getting approved and whose dates have been current in the past, they start applying for 485s. It puts pressure on USCIS because now they have this whole set of green cards that they have to issue, but they have to work with the existing availability of those visa numbers. So what they typically do is they retrogress those numbers back. And unfortunately, that is what has happened, and that is why we see this 1 year retrogression in rest of the world category. And for India, no forward movement at all.
Well, thank you so much, Sean, for explaining all the things in a very detailed process. So, like by listening all to these things, can we say that September Visa Bulletin has been the most disheartening visa bulletin till now, or were there more?
This September's bulletin was definitely, I think, in the entire year, I think this was like a pretty bad bulletin. But again, historically, September bulletins are kind of expected to be bad. The reason is we are at the last month of the fiscal year. The September is the last month of the fiscal year. And when it is the last month, what happens is USCIS, because they're trying to be very efficient nowadays, they're trying to clear out all the pending cases. So in the COVID years, 2020 and 2021, USCIS was slow because of staffing challenges. And so even in September, they had a lot of visa numbers to issue. We also had spillover. So in the years 2020 and 2021 and even 2022, what happened is they were able to use unused numbers in family-based categories. They pushed it into employment-based categories, and employment-based categories had more numbers than they are typically supposed to have. So they had more flexibility in advancing the visa bulletin, the visa numbers, even in the later part of the year. Unfortunately, this year, because now we are past COVID. Now things have become a little bit efficient. USCIS is uh, very efficient, and not only that, even the consulates, their consulates are acting in full capacity, working in full capacity. So we are not really seeing a lot of family-based visa numbers getting wasted. And what this means is there is less scope for the visa numbers to fall from family-based categories to the employment-based categories, the downward shift. And what that means is there are we just don't have the green card numbers available out there because there are regulatory limitations, and
Right.
USCIS has to follow those regulatory requirements, and the numbers are given. So USCIS cannot really do anything because whatever is out there, it's available. They're trying to issue all those green cards. So unfortunately, because of that reason, when it comes to the last month of the fiscal year, their hands are tied. and they're not really able to move the visa bulletin any further. And this being the last visa bulletin of the fiscal year, it was pretty disheartening, but it's kind of expected. But the good news is that starting October is when again USCIS they'll be able to start issuing the new green cards. Department of State, they'll have flexibility to open up the visa bulletin.
Right.
So definitely, I think October bulletin is something that everybody should be looking for, because October bulletin will kind of give a prediction on what's going to happen for the entire year. The reason is they have two charts out there: the date of filing chart and the final action chart. And what the Department of State will try to typically do is they look at all the numbers that are available, and this is for the 2025 fiscal year. They will not only publish what is current for the October month, which is the final action chart, but they also try to predict what could happen in the entire next year based on the numbers that they have, and they will try to give a prediction, and that is your date of filing chart. So October visa bulletin, we do expect a little bit of decent movement, at least for a lot of categories. India is still going to be challenging. The reason is India is still a heavily subscribed, oversubscribed country, but at least we will be able to make out good predictions. We will be able to see how the next year's visa numbers are going to start getting allocated. So I think September visa bulletin, even though it is bad, October we're very close. The October visa bulletin will typically come anywhere between September 10th to September 20th. That is my guess. They typically try to give it in the second or third week. So middle of September we should have this October visa bulletin out, and I think I do expect a positive movement, at least in the October's visa bulletin. And a lot of people, I think they're stuck because these numbers are not moving. But hopefully, at least the visa numbers in the next month, the October's bulletin, will at least make a positive impact on everybody that's waiting for green card for such a long time.
Yeah, that's a kind of a relief thing that you said right now, because maybe if September wouldn't be that good, then at least we can hope for October, right? And applicants out there, you can be hopeful for the October bulletin. So I think it's a kind of a good news also, not for the September month, but at least for the October month. Okay, that's really nice, Chan, that you have explained us. Okay, guys, so let's move ahead with our second question. That is, how might this retrogression in the EB3 category impact applicants who were expecting to file soon? What strategy should they consider?
Sure. So normally what's happening is people have these I-140 approvals, because I-140 approvals are typically, I mean, once the perm is approved and the company starts filing the I-140, they go through that process. And once the I-140 is approved, normally what a lot of people do, especially from these oversubscribed countries, especially India, China, Philippines, and Mexico, the four oversubscribed countries, normally what people do is you're just looking at the visa bulletin and just waiting to file the case. So normally people who are very, very close, you look at the visa bulletin, and if your date is close, so the applicants are actually waiting to see the date become current, and then they file the I-485. So if the date becomes current, one is able to file the I-485. And now with this retrogression, what is happening is people who thought, because normally you would expect the dates to move forward each month. So each month you would at least expect some forward movement. And now this retrogression, what it is doing is, instead of people, because people get everything ready to do their I-485 filing, and now you don't even know when the dates will become current again. So the impact is, it is completely delaying their I-485, because if somebody files their I-485, they can stay back in the country and they will get an EAD card, they will get advance parole to travel. Now all of these this is going to be delayed. So now this delayed processing, it's going to cause a lot of anxiety, because now they have to maintain status and some other legal status, and they don't even know when they can apply for 485, when they can get their EAD card, and so on. So it's going to jeopardize their entire process, and it's going to completely delay their I-485. That is that is like the most the worst thing that could happen to people who are impacted by this retrogression. And also the extended wait time, because now the dates moved back. It's the extended wait. They don't even know how long they have to wait until they can get their green card. And not only that, their entire plans for employment, relocation, or any other professional goals, all of their plans will now have to wait until the dates become current. And this is going to cause a lot of uncertainty, a lot of anxiety. And it's unfortunate, but I mean, Yesterday, I had a case where one of our clients, he's from Pakistan, and he really thought his date was going to become current. His date is in 2022. And a couple of months back, he was only 1 month away from his date becoming current. And he's a very hardworking guy. He got his bachelor's degree from a very good school, is highly qualified. And he thought his date is current a long time back. And instead of moving 1 month ahead, every month it is going back and back and back. And this month he found out his date went 1 year back. And this entire uncertainty, anxiety, he cannot even travel out of the country, and his spouse cannot travel out of the country. So this entire retrogression is creating such uncertainty and anxiety, not only for the applicant but for his entire family. And his entire life plans will now have to stay and wait till the dates become current. So these are the kind of things that unfortunately impact, because these are impacting people in a big way. But again, all one can do is review the monthly visa bulletin, monitor it, keep checking this every month, because the visa bulletin gets published every month. And just hope and pray that the date becomes current, and file as early as possible. General pointer for everybody is, if the company's perm is approved, do not wait to file your I-140. Try to get the I-140 filed the minute you're eligible. Your perm is approved and you're eligible. The reason is sometimes I-140 takes a long time. You might get an RFE. So you don't want to have any surprises. So if your I-140 is approved, you typically don't have any surprises. So even if your date is not current, make sure your company files the I-140 as quickly as possible and get it out of the way. And then get all your documents ready, and the day your date becomes current, the minute you're able to file your case, get your filing out as quickly as possible. The reason is already there's a lot of backlog, and there's going to be some wait time, because even if you apply for 485 when your date is current, it does not mean that you'll get your green card in 1, 2, 3, 4 months. USCIS has to do a lot of process. They do a lot of background checks. They have to do their entire process. So if they get more
I think due to some technical issue, Chand is not here with us, but we'll be getting back to him. And I think there is some kind of issue right now, but that's okay. We are going to manage those things. Chand, can you hear us right now? I think there's a kind of technical issue right now. Okay, guys, no worries, as the show must go on. We'll be right back after a few times, so don't go anywhere. Keep watching Immigration and Jobs Talk Show and start posting all your questions as soon as possible, because we are going to take all of them together. Thank you so much, and we'll be right back, so don't go anywhere. Thank you, and keep watching.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry. Exceptional employee benefits. Highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.
Welcome back to Immigration and Jobs Talk Show. I'm Sam, your host, and today we are joined with none other than Attorney Chand Parvathaneni. So now it's time to pick up our viewers' question. And before that, I would like to welcome Chand again. Hello, Chand. How are you right now? Is everything good?
Hello, Sam. I apologize. I think looks like I got disconnected, and I just realized. And I think for some reason my Wi-Fi went to another Wi-Fi, and I got disconnected back now.
Yeah, no worries. That doesn't matter. Your energy and your smile on your face again. That matters more. So please, Chan, continue with your whatever you were saying, giving the information. Then we'll pick up our viewers' question. First, you complete your thing.
Sure, sure. So we were talking about the retrogression in EB3 and how it's impacting people. So now, because of retrogression, and I think what's going to happen is their I-485, their application, because people expect to file I-485 as the dates keep getting current. And now, because of the backward retrogression, the dates moved back. So anybody that is close to filing an I-485 now has to wait until the date becomes current. And normally, as people are expecting the dates to move forwards, anybody that is close, they get all their papers ready. And now, unfortunately, what's happening is they have to wait and just let the date become current. So what people should be doing is, it's unfortunate, but there are some things people can do, which is evaluate your opportunity, is other opportunities that you might have. Look at EB1 category, look at EB2 NAW category. For people from India, especially, you have been working in this country for such a long time, and your dates are not current. 2012 is the current priority date. So definitely we know that a lot of people are working for more than 10 years, have a master's degree, such a high advanced degree, and many of you are from very, very high, very, very good schools, top notch schools, still not able to get a green card. So what you should do is evaluate your options for EB1. EB1 has multiple categories: EB1A, probably also EB1C, depending on what your career priorities are. So people from India definitely should be looking at EB1A and EB1C. People from India who are on in EB3 category, you might also want to explore EB2 NIW. People who don't have an I-140 filed by their employer might also look at EB2 NIW. So look for these other alternatives, and also look at EB5 investment option. EB5 investment option is a lot faster than EB2 or EB3 right now for India. So a lot of people from India, you should also be looking at EB5 option. EB5 option is, again, not an easy option. You have to invest a lot of money. But again, a lot of you, because what I see is there are many people out here who have been living and working in the United States for such a long time, and they make a lot of money because they're highly qualified, highly talented, and they have saved up a lot of money. And for them, EB5 might be practically be feasible. So EB5 is something that people should explore, because right now EB5 is still pretty good for Indian nationals. So EB1, again, I think is a good option, and a lot of people should explore. So at least trying to see if you have another category is what I think everybody should explore when you're impacted by retrogression. And then just keep monitoring the visa bulletin, okay? Because the visa bulletins will start again moving forwards from October. So just keep tracking it for at least anybody that is pretty close to the priority dates from the September's bulletin.
Okay, that's really nice that we got this much information from you, Chan. Okay, so I think now it's time to pick up our viewers' question one by one, so that we can solve their queries, whatever they have in their confusion things and all. Okay, so let's pick our viewers' question one by one. As we got a first question, that is from Anjali Mehta. So she's asking, I have left 7 months in my CSPA age, and my PD is just only 1 day away to BCM, current F4. So what's the prediction when it will current?
Sure. So the good news, I think what I see from your question is the priority date is only 1 day away, and we have 7 months left. So what that means is we at least have another 6 visa bulletins approximately to monitor before you age out. And since it's only 1 day away, and we know September it's bad, but October, the entire visa numbers for 2025, they will USCIS Department of State typically starting from October, they're allowed to use the 2025 visa numbers. So I'm pretty positive that if it is only 1 day, you should definitely see that forward movement in the next bulletins, because they do get that new quota, that 226,000 minimum in family-based immigration, that comes in the month of that starts from the month of October, and is valid for the entire 2025 fiscal year will start. So I do really see, hope for you if it is only 1 day away. It's 1 day away and we have 7 months time left. So I definitely think that you might become current My guess, if you ask me right now, is probably October is your very good, decent chance, because October visa bulletin always starts out with the 2025 visa numbers.
All right. I think, Anjali, you got your answer. Thank you so much, Anjali, for asking our question. Okay, let's move ahead with Satish. We received from YouTube, and his question is: My I-140 got approved with priority date on Jan 2023 for EB3 category. What are my chances of getting green card? Are there any alternative options I can use other than just wait till my turn comes?
Uh, so, Satish, I'm assuming you're born in India, and the reason is the country of birth has a major impact. And somebody with a country of birth in India right now uh, is is going to be at a disadvantage. The reason is India is heavily oversubscribed, and India EB3 category right now is 2012, and your priority date is Jan 2023. So recently, a report came out, and USCIS publishes this data. They publish how many I-140s are approved out there every year. And what they found is, and again, this is a couple of months old, I would say like 3 to 4 months back news, based on the outstanding I-140s, there are 1.2 million Indians who are currently waiting for their green card. So EB2 and EB3 and EB1 category, we almost have 1.2 million people who are waiting for a green card. How many numbers do we have? In the entire employment based category, in the entire year, we only have 140,000 green cards, but that is for the entire world, everybody. So for everybody, we only have 140,000 green cards. And when it comes to India, only 7% can be given. So 7% of 140,000, I mean, it's probably around 10,000. So we only have 10,000 green cards that can be given to India. Uh, I mean, if you look at the strict interpretation of rules, so that is not really a lot. The reason is we have more than a million people out here who are waiting for a green card. So assuming the rules are the same as what they are right now, if you have a priority date in 2023, it'll be a lifetime. Uh, if the rules don't change. So it is very, I mean, upsetting to hear this, but the way the current rules are designed, it is, I mean, they have very, very bad rules over this country quota, which puts people who are born in India at a disadvantage because of the 7% quota. So, what are the options? So, I mean, based on the current queue that we are seeing, it would be a lifetime. I mean, there are some predictions that are saying more than 100 years. I would definitely think anything less than 25 years is probably very optimistic. So, what are the options? The first option is, I will tell you, if you have a child who is born in US, for example, if you have a child right now who is born in India, sorry, born in US, when that child turns 21, that child can sponsor you for a green card. So, because a lot of Indians who are working here, they have children in US. So, if you have children in US, we definitely know that in 21 years they can sponsor a green card for you, and there are no quotas for that green card. As a citizen, if a child is born in US, the child becomes a US citizen, and that child, when he or she becomes 21, they can sponsor for a green card. There are no quotas, there are no limits. So at least in 21 years, that is a guaranteed route. But when it comes to employment, I don't think in 21 years with a 2023 EB3 priority date, we have good scope. And the other practical options are, I think you should definitely explore for EB1. Look at EB1A. Not that easy, and if it is that easy, everybody would be running after it. So it's not that easy, but because, I mean, as you keep proving yourself in your career, it does become a valid option for a lot of people. So look at EB1A and look at EB1C. EB1C is where you have to work in the foreign office of a company, and then after 1 year you come and work in the US office as a manager. So it could work for some people. So look at EB1C, look at EB1A, also look at EB5. EB5 could be an option for some people. So these three are, I think, some options that people are exploring. But if not, I mean, unfortunately, if rules don't change, there is a big problem. That being said, you never know. I mean, tomorrow you might have a legislative action and they might change the rules. They might do something about the country quotas, or they might understand that As our country expands, we need more specialized people, so they might increase the quotas in general. So many things could happen, but if assuming the rules are what they are as of today, it is probably at least 25 years, definitely more than 25 years.
Okay, thank you, Satish, for your question. But Chand, I want to ask but what about the documented dreamers, and what about children who don't get the GC? What would you like to say about that?
Yeah, I mean, I think it is like really, really very disheartening and very sad because I personally know a lot of people. They have been contributing and paying high taxes for a number of years, and like 10, 15, 20 years. And they're still not able to get a green card because they're stuck in this green card queue because we have this rule about country quota. And what happens is, I see a lot of people who have children born in India, and when the children are like young, maybe like 5, 6, 7, 8 years old, they come to US. And now the children are becoming adults. According to immigration, it is not 18 years, it is 21 years. So when a child turns 21 years old, the child basically becomes an adult. So after 21 years old, the child cannot be a dependent of the parents. The child has to have their own immigration status. And because of this extended green card delays, a lot of people, a lot of children, they're aging out. And unfortunately, once the child turns 21, they can't stay on H4. They have to convert to a different status, maybe H1, maybe F1, and they have to pursue their own immigration status. So it is pretty bad. And right now, the documented dreamers, when we say documented, these are people who came into the country legally on a legal status. They came on H4 or some other valid status. They've always followed the rules. And we call them dreamers because they came in as minors. They came in while they were children. And because they came in when they were like 3, 4, 5 years old, their entire life is in US. Their entire schooling is in US. So they don't even know other countries. And now when they hit 21, they don't even know what to do. They just out of status. And some people, uh, they come on valid visas. For example, they come on, parents come in as tourists. They come in as tourists, and they come in legally. So they are documented. They come in legally. They're documented, but they overstay their visa. So we have these cases too. So we have cases where people came in legally, uh, they're documented, and then they fall out of status. And then we have some people who come here legally, and then they maintain their status throughout. But unfortunately, the rules today say that the minute they hit 21, they're probably they're going to be out of, out of luck. They have to pursue their own green card process, and this is a problem. And for the dreamers, we do have so a lot of cases. What is happening is, we have these kids who are into the country, and their parents, because their parents did not make sure they had valid status, the kids are out of status. So for those people, so currently at least we have a feature where those kids can get EAD cards, so, and they can stay back in the country. Unfortunately, for people who have always maintained status, who have never fallen out of status, like H4, right now there is no option, and the option is they still have to keep maintaining their status. And if they fall out of status, they will have a problem for their future immigration status. So when they go to the country and they try to come back in, they will have a problem. So we do know that we have elections coming. We do know that we will have a new president, because whether it's Kamala Harris or whether it's Donald Trump, we're going to have a new president for sure. So we just have to wait and watch and see how, for the dreamers especially, how the new president, whether it is Kamala Harris or whether it is Donald Trump, working along with the Senate and the House of Representatives, the Congress, we have to wait and see what kind of new rules will be framed, and if any recourse will be given to dreamers who fell out of status without no fault of their own, and see how things will be implemented. How the DACA is basically what helps people get EAD cards. We will have to see how that will be implemented in the future.
Well, we could just say all the best and good luck to our documented dreamers. Okay, so let's move ahead with our next question that we received from Meera Patel. And this is from YouTube. She's asking if I reach the required physical presence for N400 citizenship and file N400, can I still travel? Will my travel dates or physical presence be affected? Meaning, will my physical presence minus even though I reach the physical presence and filed it timely? It's just I need to travel, but I can go back for the interview and oath anytime. Please help me. I don't know what to do.
Sure. When you say physical presence, so when you're applying for citizenship, out of the last 5 years, you need to have 2.5 years of physical presence in the United States. So normally, what happens is when you have 2.5 years or more, basically, if you meet the physical presence requirement, you are eligible to apply for citizenship. You apply for citizenship, and once you apply for citizenship, if you want to leave the country, you're completely okay to leave the country, and whenever you have interview, you can come back. The only issue is when you go for the interview, they will look at your entire travel history, and they want to make sure that you have not abandoned your stay in US. So what that means is, say you stayed in the country for 4 years, uh, and you only had 1 year out of the country in the last 5 years, and then you applied for N400, which is your citizenship application, and then you left the country before you got your interview date. And when you have the interview, when you come back, overall, if they see that you have not exceeded more than uh, what is allowed, so basically, if majority of the time you stayed back in US, you will not have a problem. So if your question is if I travel out of the country after applying for N400, as long as you do not fall out of that requirement, 50% or more in United States, and you also need to have continuous residence. Continuous residence is you need to stay in United States without staying abroad for more than 180 days. If you stay more than 180 days, if you have a valid reason, and if it is less than 1 year, sometimes you might be able to argue and show that you have not violated the continuous presence requirement. So you do need to show the physical presence, and you also have to show the continuous presence requirement. And as long as you don't violate it, even after applying for citizenship, yes, you are good to travel out of the country, and you are able to come back into the country. My wife, when she applied for her citizenship, I think 2013 or 14, she had an emergency. She had to leave the country after her application. So many people do that. There is nothing that says you cannot leave the country if you file for your N400. So you're good to leave. The only thing is make sure you do not violate your continuous presence along with your physical presence, because you also have to remember the continuous presence requirement. So as long as you're also meeting the continuous presence requirement along with your physical presence requirement, you should not have any issue.
All right. I hope, Mira, you got your answer. Thank you so much, Mira, for connecting with us and for also asking question from our attorney. Okay, let's take up Ravi's question. All right, Ravi is on the line. Let's ask first Mahidhar. The US immigration year begins every October. So, what's your prediction on F2A progression of dates, if any, for both A and B tables?
Sure. So when we talk about F2, so anytime you see an F, it is basically it's a family-based category. So in family-based category, we typically have immediate relative. So immediate relative is the husband or wife or a parent of a US citizen. And anything that is not an immediate relative, we have four categories: F1, F2, F3, F4. So the F2 category is specifically for the spouses of green card holders. So if somebody is a green card holder, they have a spouse or a child who's under 18, they qualify under F2A category. And right now, again, F2A category, again, India is one of the oversubscribed countries. So right now the F2 category is pretty back. It's a couple of years of wait time based on the current visa bulletin. That being said, October we have new numbers, and since we have a lot of new numbers in October, I definitely think the visa bulletin will move ahead. And there are two things to keep in mind. So we have two tables. One, the final action chart, and then the second one is your the data filing chart. And what happens is 1 month they allow the data filing chart to be used for 485s, and then 1 month they say it cannot be used. So for some people, the data filing chart does become advantageous. Even if you're not eligible to get a green card, a lot of times it will help you file the 485. But whether the data filing chart is allowed or the final action chart is allowed. You have to wait until the visa bulletin comes up, and it keeps changing time to time. But at least the good news is, I definitely think the visa bulletin will progress in October. I think you will see some kind of forward movement. And again, F2A category, it is very hard. And normally, sometimes I see 2 to 3 years of backlog, and sometimes all of a sudden you see it is getting very close to being current. But I'm hoping that you filed your I-130, so you do have a priority date, and all you're doing is just waiting for your date to be current either in chart 1 or chart 2. And again, in October, not only they predict the October bulletin, but very closely monitor the second chart, the B table, because that will give you what is going to happen for the entire next 1 year. So we do have to wait for another 1 month. And then next month, I think we should have a reasonable idea on what you can expect for the entire year and not just October.
All right, I think Mahidar has got his answer. Thank you so much, Mahidar, for connecting with us. Next, we have our next viewer. Let's see. Okay, so Rohit, he's asking PD October 31, 2016, DQ 22nd September 2022 visa category F2B all chargeability from Nairobi, Kenya. When to expect interview appointment letter? Thanks.
Sure. So again, when you talk about F2B category, so F2 is for dependents of green card holders, and F2B is for adult children of green card holders. And based on looking at the dates, so the priority date is 2016. So you entered into the green card queue in 2016. That's a long time back, almost 8 years back. And DQ means documentarily qualified. That means the I-130 is approved, and you've submitted all the documents you're supposed to submit, and NVC has all your documents. So right now, all you have to look for is you look at the priority date and see if 2016 is current. And normally, if the priority date is current, typically we see 2 to 3 months to see an interview appointment. And I'm not really sure the current priority date for rest of the world, because Kenya is in rest of the world. But if your date is current, normally 1 to 3 months is when you typically should expect to see an appointment letter. If not, I would encourage you to at least contact NVC, contact the consulate, and just make sure that everything is good. But when you say DQ, documentally qualified, they're at least saying that they have all the documents and you're good, and it is just you're waiting until the date becomes current. And that is something what you have to monitor the visa bulletin every month and look at F2B category. And if you see your date is current, I would expect a visa interview date very, very quickly.
All right. Thank you, Rohit, for your question. Okay, let's move ahead with our next viewer's question, and that is we have received from Deepak, and he's saying if there are additional EB1 row visas by the end of September, does it spill over to India or China in the next year? I thought any row surplus had to be used within the same fiscal year.
Yes. So EB1, because we know there is backlog in for other countries. So EB1, I don't think USA. I mean, there'll even be a spillover to next year. So what's going to happen is if rest of the world is not able to utilize the entire EB1, they'll more than likely what they'll do is they'll use it for India and China, and they will finish it off in 2024 fiscal year. So it is very rare that they will let it spill over to the next year. The reason is we already have a lot of backlog in EB1 category for India and China. So more than likely, I don't expect to see any spillover. But then again, USCIS, the Department of State, they will publish these numbers. And if you look at last year, we have 140,000 that are typically set out there. They did say that there was a spillover of 20,000 from all these other family-based categories and so on. And overall, we had 160,000 last year. So we had like 20,000 spillover coming from all these other places. So uh, rest of the world surplus, they will use it in the same fiscal year. But we might have some spillover from family-based, if at all we have any spillover. Last year, we had very negligible spillover, but we did have some. The years prior to that, we had a lot of spillover. But again, this year, I don't think that we'll have a lot of spillover. But next month, I think we'll have more clarity. Typically, by October, when the October bulletin is published, more than likely they'll give a good idea on how many numbers we will have for the next following year. So the minimum is 140,000 because that is set in law, and 140 plus whatever it spills over. Last year was very negligible. Last year we had about 20,000 spillover, so it was 160,000 overall. Uh, Rest of the world, I don't think they will let it spill over to the following year.
All right, all right. Thank you, Deepak. Thank you for your question. Moving ahead with our next viewer's question, let's see who is he. Okay, so we have received few more questions, and let's begin from again Vikram's question. So he's saying that I want to confirm about Child Protection Act is still considered or not. I filed petition under F3 category of my married son and daughters on September 2010 and approval from USCIS received in October 2014. This benefit will be given to my family or not?
So in general, the CSPA, so that act is still an active. It's an active and a valid law, and it is still valid. And what CSPA typically says is they will look at how long your immigration petition is pending. So in this case, 2010 to 2014, so 4 years it was pending. So they add 4 years on top of 21 years. That is typically the rule. And I don't have much experience with F3 category, so I'm not really sure for what happens for the F3 category, because F3 category is for married son of US citizens. I mean, I work a lot on the family-based cases, sorry, the employment-based cases. So I'm not really sure how it impacts F3 category, but I can do some research and get back to you on that question.
All right. Okay, no worries. Thank you, Vikram. Thank you for your question. Let's move ahead now. I think we have some more viewers chat, but let's first ask some different questions that we would like to know the answers. The priority date for the other worker category in all chargeability areas in Mexico has moved back by 1 month. So, what factors typically influence these smaller retrogressions?
So when we talk about EB3 category, because a lot of people, especially from India, people are highly educated. They have at least have a bachelor's degree. So majority of the people have a bachelor's degree, whoever are coming into the EB3 category. So we assume that EB3 category requires at least a bachelor's degree. But there is some other category. It comes under EB3, but you don't even need a degree. You don't even need a lot of work experience. So for example, you have a janitor or like a cleaner in a hotel. You can even file a green card for those people, even for like janitors, even for hotel workers, hotel cleaners, and so on. So other worker category means these people have less than 2 years of experience. They do not have a degree, but they're qualified. The reason they're qualified is because, for example, janitors. If US is in shortage of janitors, for example, it is not a highly skilled job. It is not a skilled worker job. It is low skilled. It does not even require more than 2 years of experience. But there is a way for them to be eligible for getting a green card, and that is what is other worker category. Somebody that has less than 2 years of experience, not a skilled worker. And what happened this month in the visa bulletin is the date moved back to 2020, moved back by 1 month for other workers category. Uh, it's a very small retrogression. And what that means is we're getting close to the end of the fiscal year. We don't really have much numbers left. Uh, Only a maximum of 10,000 green cards can be given to that category, to the other worker category. So since it moved back 1 month, what it means is there is not a lot of demand because it didn't really move a lot back. That being said, they don't really have enough numbers. So I think that's why we see this small retrogression. Uh, Again, starting from October, I think you can see forward movement. Um, and again, they don't really have enough numbers. The bottom line is they don't really have enough numbers uh, for other worker category at this point of time.
All right, all right. So we got this answer. Okay, so now let's move ahead with the next question. And we have received few more questions from our viewers. And we have received it from a YouTuber viewers, and that is Rishvi. My petitioner used the old passport to fill my DS-260 form. Now I have a new passport. When I go through my DS-260 details, the passport number isn't the same as of my new passport. Will that affect my visa interview? Please, I need your advice, sir.
Not normally, if the visa scheduling website is still letting you edit, you should edit. But if you already submitted, you're not able to edit, you go for an interview or you go for your biometrics. Make sure you show your new passport. Make sure you show your old passport. At the time of interview, let the officer know that you do have a new passport, and normally it should not be a problem. Just make sure it is disclosed at the time of the interview.
All right. Okay, thank you, Rishvi. Thank you so much for your question. And till now, I think we have almost went through all our viewers' question. I hope they might have received our questions and answers very well. So finally, okay, fine. So we have almost touched each and everyone's question, and we got to know so much things about from today's session. And finally, we have reached to the end of our webinar. And that's all. I would just like to say thank you to all our lovely viewers who participated in today's session. And thank you so much, Chand. It's a heartfelt thank you to you, Attorney Parvathaneni, for sharing such valuable insights with us today. And what can you say? How was your today's webinar?
Yeah, I think the topic I think we're discussing, I think it's I think a very, I mean, a crucial thing for a lot of immigrants because every immigrant is putting a lot of effort into contributing to the society in US, contributing a lot to the taxes, and they definitely because they do expect a green card because they're putting all this effort. They want to have a career and a life here in US, and sometimes it is really bad that the laws are skewed where some people are like contributing a lot, they're still not able to get a green card, and the reason is country of birth. If somebody is born in the oversubscribed countries, you're pretty much out of luck. And the government, unfortunately, they cannot really move things very quickly because rules are rules, and changing the rules requires legislative action. And legislative action, it is not President Trump or President Kamala Harris. When they become one of them becomes a president, it is not easy for them to just say, hey, I want this rule to be changed, and it is not done that way. There is a big process for legislative actions here in US. You have to have a bill, you have to have the US Senate agree to it, you have to have the House of Representatives agree to it. Then the president has to agree to it. So you have three parties that have to agree to a change before something becomes a law. So when we have these issues, we know that highly qualified people are getting severely impacted, and both Democrats or Republicans, they do understand that EB2, EB1, EB3, all these employment-based categories, they are really useful for the country because you're really getting talented people into the country using these employment-based immigration categories. They are, I mean, the problem is they all say that this is very important for the country because this is not illegal immigration, it is legal immigration. At the same time, we have laws that have been made in 1990s. So whatever laws we are seeing, most of them were made in 1990s, these immigration laws. And we are still following the same rules when things have changed, when nowadays there is so much of automation, there is so much of need for highly technical people, but the numbers, they're not getting revisited, the laws are not getting changed. Unfortunately, rules are rules, and the way laws are made, that's how they're made. It is not easy to change laws, it is not easy to enact a new legislation, and that is what is contributing to this mess of immigration backlogs. A million people from India who are backlogged. It is not a small thing, it is like a big thing, and these million people, most of them are contributing very very highly to US economy, looking at their salaries, because people are on H1, and H1 does require very high salaries because we have this minimum wage requirements, these LCA requirements, and so on. So all we can hope for is maybe when we have a new president, new Senate. I mean, we'll have a lot of new senators because we have one third of the Senate being replaced in the elections. Then we'll have the new House of Representatives. The whole House of Representatives, they're having an election in November. So when we have this new Congress back working from January, we just hope that at least they'll make some new rule changes. There are many bills out there that talk about making changes to country quotas, making changes to these numbers, and so on. We'll just have to hope for the best right now. And right now, things are not as good if somebody's just entering into the immigration process. They're just getting their perm processed, or they're just getting their I-140 processed, because you already have such a huge backlog. There is a million plus backlog for India. So I'm just optimistic. I do think that rules will change. I do think that they will enact new laws. How quickly, nobody knows. So we just have to wait and watch and see what will happen in the future.
Right, that's really true because people out there, they are getting so much worried about all these regular changing in policies and all, but by getting them good guidance and by updating them about all the new things, I think that will make them so much secure and they will be on right track. So, for that, I would just like to say that viewers, please contact Chand if you really need to be on right track and to know everything about immigration and jobs talk show, then please, folks out there, please contact Chand on the given number, that is 817-523-8247. I'm repeating it again, 817-523-8247. You can also email him on law@spblawfirm.com and visit his website spblawfirm.com. So thank you so much, Sean. It's always been an absolute pleasure having you on the show. We are really so much grateful and so glad that you could join us. Thank you so much, Sean. It's really great having you on a show.
Thank you, Sam.
Thank you. So, guys, if you're looking for a project placement or visa sponsorship, then reach out to me on my email, sam@higheritpeople.com. Or you can also visit our website, www.higheritpeople.com. Remember, we also sponsor H1B visas and green cards. We hope you found today's discussion valuable. Until next time, stay safe and take care. And don't forget to like, share, and subscribe to our channel, Immigration and Jobs Talk Show. I'm Sam signing off for now. Thank you.
Consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees, global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833-412-8472 or mail us at support@higheritpeople.com.